Thank you, man. No, hi everybody. And yeah, a couple of things I want to stress before we get into Noel here speaking is that we have a great alliance with all of you, the firm there, and you have access to a lot of resources through us. Certainly, Noelle Bryce, one of our top attorneys, for complimentary sessions for any of the people you're talking to. And this is a Zoom call, a phone call. They get one-on-one with Noelle. Those are great. And there's a lot going on. And I've got to tell you that at my department, we get about 10 hair on fire calls a week or calls with, urgency, things are going on. What I see a lot of, seeing a lot of issues around probate and trust planning coming in where, you know, parents have passed away or somebody's died and assets were not titled in the name of a trust. I get almost two of those a day that come in, and people are confused, nervous, they don't know what to do. And so that's a big deal. And in particular, an area of expertise for Noel. So a lot of the discussion around, everyone needs a living trust, titling assets, how that goes. I get a lot of that. A lot of trust litigation comes in. We get a lot of those and have attorneys that can deal with that. But I would say that as you're talking to clients from a life insurance perspective, I know you have a very good process for looking at things holistically. And if you're seeing any assets, on life insurance in particular, but anything else, as you're doing, these discussions that are not in a living trust, then that is a red flag where, hey, you could introduce as something helpful to them because of your relationship with us. You can offer a complimentary initial assessment with Noel and take a look at them as they're getting, their assets tightened up. So I'll just say that keep us in mind. We're here to help you in any way we can. And with that, Noel, you want to jump in?
Thanks, Paul, and thanks for the introduction. Thanks for having me here. It's always great to be here, get a little nerdy about what I love to do and how I love to help people. My goal today is to sharpen your attention to some interesting case studies that I think when you're working with your clients will give you the edge on understanding what they're going through or some things to look out for. I'll start by saying, we're all in this new expectation, right, for 2026. We all know what's coming down the pipeline with kind of the permanent changes to the estate tax exemption being at 15 million per person adjusted for inflation. So that means for a married couple, we're working with 30 million. Most married couples will fall below that on average. So that still puts them in the high net worth, but maybe not ultra high net worth. So there's still a lot of planning to be done. And I'll talk about that in a minute. But in terms of planning, either if it's on the review side, meaning they've had an old trust, got to come in and see what it looks like and dust it off, or maybe they don't have anything at all, and we really need to use and utilize this huge opportunity, given that we're no longer looking at a sunset potential decrease, but we're looking at a nice steady continuing with the 15 million plus. Fingers crossed, unless Congress, decides to throw tantrums and come back in and change that, which is totally possible given the political climate. But this is unprecedented in terms of the ultimate high of the estate tax exemption we're working with right now. So whether it's coming in for a review or doing more estate tax planning for purposes of reducing the estate tax or gift tax, this is the best time to do it. So encourage your clients wherever they are in that journey. If they're on average, a couple $1 million, maybe they've got a couple million more coming in life insurance proceeds, a couple million more in investments, maybe their house, rental property. They're already, climbing that ladder. They might not be even as a married couple at the 15 million mark. But this be a great opportunity for review. Let's dust off that old trust if they have one. A lot of the old trusts have a forced um, division of assets upon the first spouse's passing, which means that may not be necessary anymore for a lot of the folks who are not high net worth. They don't need to force split their assets if they're already working with $30 million. Okay, we might not ever project for them to get ever that high in terms of net worth. And the folks that are maybe somewhere in the middle and they're considering some gifting just so that they're more conservative, and even if their assets appreciate, they won't go above the estate tax exemption. It's a great time to look into that. The gift tax exemption and the GST are all the same with the estate tax. So there's no bifurcation. Like you can only gift this much during your lifetime, but afterward you've got the estate tax exemption. It's all the same. So we got $15 million worth of assets to gift. We could do that, and with all our current tools in our disposal, none of them got slashed by Congress, thankfully. So we could do the slots, we could do the charitable remainder trust, we can do it all. For those that are ultra high net worth, definitely want to take advantage of this uh, um, opportunity to gift, because now we're not looking at the time crunch of December 31st, right? We were kind of hoping that we would be on standby, ready for kind of hair on fire scenarios like Paul was talking about. But in this case, it would be the estate tax implications if we don't do gifting, and then it goes back down to 5 or 6 million estate tax exemption. That's a huge loss in terms of taxation upon transfer. But now we have some time, we have some breathing room, which means that this is your opportunity to come alongside your clients and say, hey, this is really important that you start the work now. We don't want to be in a situation where we're rushing, especially if Congress wants to throw a curveball. This is a great time, I think, for everyone to come in and do a review. So that's my PSA on that. Reviews are great. It gets you more business. It gets us more business. It puts the client, ultimately, that's what we're hoping for, the client in a better situation for them, the families, and their business. Okay, so we got that under our belts. Now let's think about some of the case studies I want to bring forward to you. The reason I chose these because they are granular, so bear with me as we kind of get into the weeds of them. Obviously, I can't share who these people are. You know that that's why, for confidentiality purposes. But I think I can share enough information where you are going to get a good sense of what's going on. I'm going to share maybe three case studies if we have time. The first is about business assets when they're not in trust. Okay, what are some of the issues we deal with there? So this is really touching on the funding aspect of a trust. Also, a reason why reviews are really important, because we start identifying assets that were not put in the trust. Um, and even more so, folks who don't have a trust at all. Maybe they inherited an asset. Maybe it's a new business that they've created, didn't get time to put into anything, didn't do any succession planning, all falls under that kind of business planning, estate planning overlap, and there's consequences when we don't have it in trust. So we'll talk about that case study. The second case study is gifting. We get a lot of folks who are ready to gift. Okay. The question is how? How do we gift? Can we just write a check? Yes, you can. Is that ideal? No, it's not. Okay, so we'll go through some of the basics of that, and a case study I have, which is really interesting, and what we ended up doing as a quick, easy solution for both asset protection and the client's kind of immediate goals. And then the last case study I want to talk about is fairly granular, is that when we have a trust, and it does get split, either split for the benefit of children or spouse, split meaning one person died, the assets get split into two different trusts, and one is held for the benefit of, let's say, the spouse or the children. Or maybe it's not split, but we do have assets in trust for the management of somebody's lifetime by somebody else, right? They're not managing their own trust. Fiduciary is managing it for them. There's usually some issues there with regards to how do we distribute assets? If you're advising a client, or if you're a fiduciary, or if you're doing the financial plan for a particular trust, or you're doing the investment rather, there could be some issues there between the interest of the beneficiary getting the money and the role of the trustee giving the money. So we'll look a little bit granular on that because I think it'll really help you see where some of the conflicts could come into place. But also just give you some more literacy so that if you are working with a client, you know what to look for and you will save them a lot of time and effort and then guide them our way so we can help them. Okay, so let's talk about the first case study, which is the business asset not being in the trust. This particular case is actually a generational wealth case. So we have a family who owns like multiple businesses, and this family is a blended family. So it's both sides of folks who have remarried and their children who inherit it. So grandma and grandpa, right, have this couple businesses and then they put the assets in trust. Thank you, Grandma and Grandpa. You did great. So now we have assets passing, business assets passing through Grandma and Grandpa's trust. Perfect. That's what we want to see. So now we have sub trusts for the grandkids or the kids and the grandkids, depending on who's alive, right? And now they own it in their name, but in the name of their subtrust, which already has an estate plan within it, meaning we already know if this particular person passes away, child or grandchild passes away, we know where those assets are going to go because they're subject to the trust, and we're not dealing with probate or estate question marks about who gets what, where, and how. And that's important because we want to keep it within the family, right? This is like a generational family business. There's sentimental value, there's revenue, there's a lot of moving pieces. And it's also on this side, it's California. So California real estate. So there's a lot going on there that we want to make sure we keep the books clean. We want to make sure assets transfer cleanly. Now, the trust, even though it anticipated going to the kids and grandkids, it actually required at a certain age for the assets to come out of the trust. I think it was like 35 or 45 or something like that, which is also common, not a problem. But that means then at that point, it's no longer in the trust and it's in the individual person's name. So if they don't go turn around and get their own trust, we're stuck with probate being the only option to transfer that asset. So grandma and grandpa did great. They set up a nice foundation. Kids or grandkids, once they turn of age, then the asset's no longer subject to the trust and then it's in their name. And so this happened exactly with one of my clients who inherited the asset from grandma and grandpa, and then they passed away, but did no planning of their own. And then we have to open a probate strictly for those business assets, which is silly because the government has no interest in coming in and looking at I&Es of multiple family businesses and trying to appraise them and going through this whole process when simply there could have just been a trust in place or even an assignment of beneficial rights to another family member, or they could have been a better draft of trust that anticipated assets for the person's lifetime. Therefore, we wouldn't have to deal with, well, what if when they're 35 or 45, it comes out of the trust, right? Because then we have to do more planning. If it never said that, if it was a lifetime trust for the benefit of the kids and the grandkids, then we would never actually be subject to probate. The only thing we'd be looking at is who's alive at the time, right? Because if the person died, their lifetime trust would say, okay, then it goes to their kids or it goes back up the chain to siblings, right? So we have an estate plan within an estate plan. And so this makes business succession, especially for generational wealth transfer, awesome. Awesome. And not only awesome for purposes of getting probate out of our hair, but for asset protection. Assets that are in a lifetime trust are asset protected. If it gets into their individual name, it's fair game. So we ended up starting a probate and we're, I think, 18 months in. Not ideal, completely unnecessary, and could have been avoided with either a better draft of trust or if the individual who had these business assets just made a trust for themselves, assigned their interest into their trust, and now we can start the planning from there on. Okay, so Really, really important. You'll see this a lot with any of your clients who are inheriting assets. Great time for planning. Not only for how do we get this big chunk of money to your loved ones if you passed away yesterday, but how do we protect it in the meantime, right? Just if you get a big inheritance, put it in your bank account, it's probably not ideal. We could talk about ways in which not only we can protect that, but make sure there's no adverse consequences. Okay, so seeing questions, let's move on to case two. So case study two is about gifting, and in particular, we want to be alongside our clients when there's discussions surrounding gifting, right? On the estate tax planning side, but also just sometimes parents and loved ones, grandparents, they just want to be um they want to be givers and they want to help. And it doesn't mean they're ultra high net worth or ultra rich and they're just trying to get a deduction on, let's say, income taxes or whatever. They just want to help. But wanting to help is also, you need to do it the right way. Okay, because once money transfers hands, not only do we have a taxable reportable event, we also have asset protection considerations. How do we mitigate the risk? If you transfer funds, write a check or wire funds or pay for somebody's something or other, um, we have to look at the liability related to once the assets hit that account, they're in that other person's name. If they get a lawsuit that day, those funds are up for grabs, and we can't move the funds after the fact and say, well, oops, we didn't mean to, right? It's a voidable conveyance potentially, and so we have to be very careful how we gift the assets so as to not um, cause any concern with liability. In this particular case, I worked with a widow who's high net worth. We're working on the allocation of the assets because they have a trust. The assets are getting split into the bypass trust and the survivor trust. Huge project. They're almost, close to $30 million net worth currently. So projected for growth. And so there's a lot of work to do. And they've got two adult children who are, married and want to buy houses and all these things. So there's opportunities for gifting. And so during this allocation process, my client says, well, I want to gift $500,000 to my daughter. I said, okay, great. Let's talk about that. And she goes, well, can I just give it to her? It's like, yeah, you can, but that's not ideal. Not only is your daughter married, but your daughter's a business owner herself and has her own liabilities. And so let's think about a better way to do this. Well, I don't want my daughter's husband getting access to any of this. Okay, then you should probably shouldn't just give it to her because you don't know what's going to happen. If there's a divorce or heaven forbid, or it goes into a joint account, you can't control any of that. So you want to control how the transfer occurs. And the ultimate goal is growth, right, and protection. The best way to do this is with a trust, right? And so it's like the Swiss Army knife of all solutions, use a trust. In this case, though, it's not going to be our typical revocable living trust. It's an irrevocable trust because we don't and can't change the terms. That's the way the IRS is going to see the transfer from her to her daughter as a completed gift. Okay, so it goes from her to her daughter, reportable event. The daughter then has full control of the trust. So we did a simple irrevocable trust from mom to daughter. And instead of just taking, 500,000 and putting it in a trust bank account, because that's also not ideal. We utilized this client's existing LLC, which had a property in it that she sold, and basically the cash was just sitting there. And I said, why not let's just put the LLC membership interest into the trust. And now your daughter would not only be the, trustee and manager of the trust, but she's or a trustee of the trust, she's also a manager of the LLC. And so now we could take the LLC bank account and do whatever we want, right? We can invest, we can swap assets in and out because it's a much easier structure to operate, boots on the ground inside of an LLC rather than inside of just like a trust bank account. Easier to work with lenders and transactions and close on properties. If there's obviously enough collateral or enough money inside of the trust. then having them to, review the trust document, who's the trustee. We got to send notices to people. If it's inside of an LLC, it's like, this is it, this is it, this is the LLC. The trust is the member owner, 100%. We're done, right? The analysis is over for purposes of third parties. And it's asset protected double because not only we have the irrevocable trust, but now we have the LLC underneath it, operating as a legitimate business. Really neat tool, not super difficult. Will not only now keep the potential uh, creditors out, but the spouse is really not in control at all. There's no possibility of commingling anything. It's literally inside of a different trust under a LLC bank account. Like there's just no way that that's going to happen. And then the trust anticipates, hey, if the beneficial interest for the beneficiary, the daughter in this case, the daughter passes, what happens then? We have a plan for that. The subtrusts in the trust, it goes to the kids or it goes to this other sister or it goes wherever we want. So long as it's in a trust, we have a plan for it. And these irrevocable trusts can continue being managed. And we just have to make sure there's enough trustees to keep that narrative going. And so this trust, even though it's outside of this daughter's, usual, maybe revocable trust or married assets, she's in full control of it, and then she can direct it where she wants to go if ultimately she decides, well, I want it to kind of funnel back into my trust if I'm dead. Okay, fine. She could do that, or we could draft it where she can't do that, and then it kind of she's just stuck with you either lose it or take it out. The part that's irrevocable is the fact that the daughter is the beneficiary and the mom can no longer change her mind about the gift, right? It's a completed gift. Now, once the daughter's the beneficiary, in this case, we have the daughter also as trustee. So she's in full control and she's the manager of the LLC. So the LLC can do whatever the LLC wants to do for purposes of transacting business. It just can't go against the trust's rules. So if the trust says no creditors are allowed to be the owner or the assignee, or if the trust says spouses are not allowed to be beneficiaries, then the LLC does have to maintain within those boundaries. But but the trust is under the full control of the beneficiary, and so there's a lot of discretion with what the LLC does for purposes of investment. Is the goal really for it's we're not trying to put operating businesses in here. We're doing stocks, bonds, and cash investments, or maybe even real property if it's appropriate. So the irrevocable piece is really to accomplish the gift transfer. And then at that point, the beneficiary can do what they want. It's part of their estate, and then they could either, redirect it or keep it where it's at. Is this the most straightforward way? No, I mean, straightforward, they just transfer $500,000, put it in your daughter's bank account. That you don't need an attorney for that. But it's also not that complicated where we're sitting around drafting really complicated stuff. The risk of doing it with just transferring funds is too high. I would never recommend it. And doing an irrevocable trust is also not that complicated. So it's not like we're um, keeping assets away from anybody or we're putting in trustees that they don't know. She's in full control, so it's not an issue. And it's not a super expensive project either. But I think the value that it brings for purposes of risk mitigation and control is significant. Um, you really don't know when a liability arises or arose for the person you're gifting to. And so there are a lot of rules for clawing back those assets and voiding the conveyances. And so as an advisor, you really should not hang your hat on the fact that things are going okay today, right? Or yesterday or tomorrow, because you just really don't know what creditors can get their hands on. Okay. The trust in this case is a present gift and it's a completed gift. Meaning the mom said, I don't want $500,000. I don't want the income from $500,000. I don't want to control it. I literally just want to give it to my daughter. Done. And then I report to the IRS that I used $500,000 of my gift tax, exemption, state tax exemption. So it's a full control release and a full asset release. There are other trusts where that's not the case, right? Maybe we're gifting business assets over a period of time, or the person who gifted it, the grantor, is still benefiting off some of the income or has some control. In this case, it's a full completed gift. And that's because that's what the mom wanted, right? If the situation were different, we could draft the trust differently. But I think ultimately the benefit is the same, is that we're using a controlled structure that's asset protected that we can creatively draft to meet our needs, and we're not letting the whims of third parties and circumstances take what is otherwise a helpful, beautiful thing mom is doing for a daughter and making it super difficult and regretful that it shouldn't have been planned a little bit differently. For purposes of the tax returns, um, it does not have to be three tax returns. So mom will have to say, "Hey, I gave my daughter 500,000." That's a given. It's a reportable event. Now the trust has its own EIN, and the LLC is its own EIN, but the LLC doesn't have to be a partnership. The LLC could be a disregarded pass through to the trust, and then the beneficial owner, being the trust, um, is has the daughter as the beneficiary, and so there always could be a pass through K1. The income can be, if needed, the income can be reported on the daughter's personal returns. Otherwise, yes, we would need at least a trust return, or an LLC return, depending on what the CPA determines for that. But it doesn't have to be that super complicated. And I'd say if that's the pushback, the fees for doing a trust return, then so be it. I would say that's cheaper than an insurance policy or litigation fees to claw back funds from liability or divorce or whatever the case may be. So it does not have to be that complicated. And I think if it's structured correctly with the pass through, seeing that, only the daughter's a single member LLC, the daughter's the only one controlling everything, it really shouldn't be too difficult. Plus, the daughter has a, separate protected income producing vehicle that she's fully in control of. That's a sweet setup. Case three, we're talking about a very granular issue, but I think as advisors in this field, it'll sharpen your, knowledge and the things to look out for and how to be sensitive in these situations. This particular case was a split between two spouses, meaning they had a trust, the assets split. And for some reason, I think they're part liability, part control. The spouse that survived was not managing their own assets. So husband died, left money for the spouse, the wife, but she was not the trustee. Okay, so we have somebody else managing wife's assets. Not very common, but sometimes this happens either because we want to make sure that wife is not, either taken advantage of, or maybe there's a blended family and we want to make sure we take care of her, but also leave money for maybe kids. In this case, there is a child. So a lot of reasons. But the particular issue, the granular issue I want to bring up is the fact that the trustee has an obligation, fiduciary obligation, right, to manage funds for the benefit of the beneficiary. We all know that. This is not new information, but here are the facts. The main two assets in the trust is the primary home. That should ding a lot of bells in your mind, like, oh gosh, okay, how does a trustee take care of the wife's home? And then there's like a $2 million brokerage account, pretty significant. Now, the fiduciary responsibility is to manage the funds for the benefit of the beneficiary, but we have to look more and deeper and closer to what the trust actually says and instructs and mandates for the trustee. So there's usually a couple different standards. There's either may or shall. And in the legal world, those are very different things. And yes, there has been cases about this. So may is exactly what it sounds like. The trust may, right? They have a discretion. They may do it or they may not do it, and they're not liable if they choose not to. Meaning, if they say, no, I'm not going to buy you a Lamborghini, then they may buy the Lamborghini, right? Not shall buy the Lamborghini. Make sense? So the shall is you got to do it unless the trust says otherwise, maybe dependency on alcohol or whatever, special needs or whatever the case may be. Obviously, those are way exceptions to the rule, but the rule is you shall. So you shall do it. You just got to be faithful to what the trust says and go ahead and distribute. Now, underneath the may or the shall, we usually have standards of distribution. And there are quite a few. By design, on average, people use one or the other, people meaning the drafters. And then sometimes people just say, well, I'd want it only for this specific reason, like education or health. But usually it's comfort, welfare, happiness is one of the standards that's used, and that's really broad. That's essentially like you do it because it's for their comfort or their welfare or their happiness. Happiness is very relative these days, so it's going to be hard to win that battle in litigation if the trustee says, well, I don't want to give this to you, even though it says shall, it's not for your happiness. Well, who are you to determine that, right? The other standard is health, education, support, and maintenance. Okay, recognize that that is not comfort, welfare, happiness. Something that is for somebody's health, support, and maintenance and education is not necessarily that broad. Okay, so there could be an argument made that, hey, I as the trustee don't feel that this falls within the standard. I'm not going to distribute based on these reasons. Now, the issue here is that the investment advisor in this case, who may also be the trustee, sometimes they are one and the same. Their job is, yes, to make sure that the wife has enough money for the rest of her life. Okay, but it can't go against the fact that the wife is entitled to comfort, welfare, happiness distributions. Okay, so that's a conflict because if the wife wants to travel Europe for 3 months because she's mourning the death of her husband, technically the trust would say yes, you must. If it's a shall for comfort, welfare, happiness, for principal and income, you got to do it. It's not your job to say, no, I don't think that's a good idea. You should just stay local and go to Big Bear or something. A trustee can't do that, okay? That they don't have the discretion to do that. But okay, if it says may, okay, and if it's may for health, education, support, and maintenance, then there's a discussion point. Is it wise? Is it financially prudent? Because the trustee has to be a prudent investor. So is it financially prudent to spend all this money, go to Europe and, pay a bunch of unnecessary expenses if we could do it a different way, right? Because if you go to Europe and spend all this money, you're not going to have enough for the last 10 years of your life, right? You're not going to have enough for a long-term care event, et cetera, et cetera. And so very interesting case. And I didn't make it up. And so the other issue becomes like maintenance of the house itself. Okay, she wants maybe an add-on to the house or wants to redo the kitchen or whatever the case may be. It's interesting that the trust was set up this way. I think it was legitimately set up for whatever reasons for the family's needs. But the wife not having control over these issues when she's the one living in the house and causes some potential conflicts. And so I guess the takeaway here is, as an advisor, understanding the financial prudent standard and the role of the trustee, but also being compassionate to like the needs of the family and what really a trust is going to do when it's used. It's great if somebody pays a bunch of money to a fancy attorney to draft this giant trust, but like doesn't actually contemplate, well, what happens, right? What happens when the assets are actually managed by somebody else. How are we going to avoid conflicts before they come up? How are we going to resolve disputes before they come up? And that's really the benefit of working with attorneys who care, like our firm, who are with families throughout most of these, if not all these transitions in their life, who are helping the beneficiaries on the side when we stand behind the trust we draft, right? We help the families after our clients have passed away. We help their loved ones to actually carry it through. Um, so really important granular issue there for fiduciary responsibility for the beneficiary. Obviously, in this case, it's maybe not as common. I would say the more common situations is I want to leave funds for my child, right? But my child's 20 and wild and crazy. So I'm going to set the age to whatever, 40, 45. And then the parent passes away. Now we have a trust for the benefit of an adult child who turned out maybe to be a very responsible 23-year-old. Who's just like, I'm in medical school, I've got a mortgage and I've got kids, and my parents left me, this huge inheritance that I can't control because they put in a 40 age limit. And now I have to go through a trustee, which is not me, to get any money from my inheritance, right? So that example is, I would say, way more common. Necessary safeguard. We usually want a proxy for maturity. Like age is a good one because we don't want the child coming in, even if they are 21 or 23, if they haven't really matured enough to be responsible, especially if the assets are large, millions of dollars. But there has to be a way where the trustee, whether it's a professional you're using, or another trusted family member, that we anticipate these issues may come up. Is it for their comfort, welfare, happiness? Is it for their health, education, support, and maintenance? May they distribute? Shall they distribute? I have a lot of clients who say, if it's for the down payment for their first house, do it. But the trustee might say, well, if we do it, then there won't be enough for the rest of your life. It's like, but that's not the standard. The standard is not to keep assets in trust for the rest of that beneficiary's life to last them that long. That may be prudent if you were their financial advisor, but it's not your role as the trustee of the trust tells you what to do when managing those specific assets. To the best you can, you want to stretch them and you want to grow them, but not to the exclusion or denial of a legitimate request by a beneficiary to say, hey, I want money to pay my down payment on my home or to pay off my school loan or whatever the case may be. So, obviously, we know that the fallout of that is litigation. We don't want to do that. Hopefully, we can get an attorney who can come in and do some kind of settlement agreement or slap the trustee's hand, figuratively speaking, and say, hey, you got to bend a little bit on this. It's not okay that you're taking this position. Education goes a long way, but I think as advisors in this field, you may have clients who have these kinds of grievances, or they're expecting an inheritance, or they have an inheritance, the trustee's not cooperating. There's solutions. We don't have to go, heavy and start litigating right away, but really important topics. This is the stuff that I deal with all the time on the ground. Uh, it's great. It's good work, and I think you seeing a little bit of what's going on the ground is all the more reasons why internet trusts by template programs, they're just silly. Really, you're just giving the family a headache if you allow your clients to do those kinds of trusts, especially if there's a lot on the line. Children, aging parents, a lot to talk about. So thanks for having me.